Hello, I'm attorney Allan Friedman. I'm here today to talk to you about criminal orders of protection in context with domestic violence cases. Now, in almost every single domestic violence case, you're going to have a criminal order of protection. Automatically, by statute, a domestic violence case requires a next day arraignment in criminal court. So that means that the next business day you'll be appearing in court and a judge will be issuing some form of a criminal order of protection. They vary from a partial order of protection, which is you shall not assault, threaten, harass, annoy, abuse, stalk, or interfere with the protected party. They go to next to a residential stay away order, which means you can have contact with the protected party, but you can't enter their residence. And they go all the way up to a full no contact order, means no contact with the protected party. And unless you ask for what's known as a Fernando A hearing and the time of the entry of the order, which gives you an opportunity to ask for an expedited hearing in a prompt manner to contest the entry of the order, basically that order is going to sit there until it's modified through a motion. And very important to know, if you're the recipient, if you're a client of mine, or if you have a domestic violence case pending here in Connecticut, very often victims of domestic violence cases will contact you incessantly because they miss you, they want to contact you. They're not subject to the order of protection, okay? So a victim, it's perfectly permissible for a victim to pick up the phone and call you, okay? It's perfectly permissible for a victim to send you text messages or emails, and I've had many situations where the victims have done just that. They've text messaged my client dozens and dozens of times, and eventually my client will break down and respond back. And very often it's that response right there that results in a felony arrest. So you cannot contact the victim. Even if the victim contacts you repeatedly, please return my text message. Even if your contact is innocent, hey, I can't contact you. You can't do it. You can't contact them. Don't contact the victim. It's very important to obey the protective order. The victim doesn't have the power to modify an order of protection. Only the court does. You're going to be warned by the judge when you have your arraignment. When the protective order issues, the judge is going to tell you this, that only the court has the order. It's a felony. It can be either a Class D or a Class C felony by punishable up to 10 years in jail. If you violate this order of protection, the courts take it very seriously. The orders of protection, it can turn your misdemeanor domestic violence case, it can be very easily rectified. It's going to have a favorable disposition into a very complex situation if you violate an order of protection. So my advice from a professional level is consult with a lawyer such as myself about your protective order and the contours of it to make sure that you're not violating it, and don't have any violation of protective order. If you feel the protective order is too restrictive, give me a call or speak to your lawyer, and then work to have the protective order modified. There's a lot of ways to have the protective order modified. If you engage in couples counseling or anger management therapy, you can make a motion to the court and let the court know. If you're in the family violence education program, you let the court know you've taken a couple classes, you're making steps through anger management, you're doing everything possible to ameliorate the situation. The court will be comfortable, as long as the victim's on board, to modify the protective order to make it less restrictive or possibly make the protective order go away, to let you back in the house or let you have contact with the victim. That's the way to do it. Don't take the law into your own hands and try to modify the protective order yourself, because if something goes wrong and the police get involved, you're going to be charged with a felony. It makes things a lot worse. Every year I do dozens of cases where people are charged with violation of a criminal order of protection. They're very serious cases. The bond gets very high, particularly we have multiple counts. You don't want to be in that situation. So in summary, if you have a domestic violence case pending, recommend you speak with a lawyer who works in domestic violence about the criminal order protection and make sure you don't violate it. If you have any questions or comments, please feel free to post them at the bottom of this video. I'd be happy to answer them, share them with the community. Feel free to subscribe to the video if you like the content. I'll be posting more. And Also, feel free to call me for a free consultation. Even if I'm not representing you, I'd be happy to discuss your case and give you a free consultation and give you a second opinion. Thank you for watching. I appreciate it. Have a wonderful day.